In the sessions shortly. A very good morning to one and all present over here. Sanchita and I, Shivani, extend a cheerful welcome to you all in today's webinar on recent judgment on Section 377 of Indian Penal Code, a case of transformative constitutionalism organized in the wake of 75th Azadi Ka Amrit Mahotsav. Before moving forward, as a mark of our university's tradition, I would like to request Aman sir to play the university school lead.
शुभ न्याय मिले अन्याय टले शुभ न्याय मिले अन्याय टले ओ सत्यमेव जयते जयति जय सत्यमेव जयते जयति जय सत्यमेव जयते जयति जय सत्यमेव जयते जयति जय सत्यमेव जयते कर्तव्य भाव की वो दीक्षा मौलिक अधिकारों की रक्षा मानवता धर्म निभाने की जन जन को सुलभ रहे शिक्षा जिसको पाने के लिए सदा हम धर्म मार्ग चलते जयति जय सत्यमेव जयते जयति जय सत्यमेव जयते जयति जय सत्यमेव जयते जयति जय सत्यमेव जयते उपकारी भौतिक संपत्ति होगी न्यारी संकल्प यदि हम अपनाते हर निर्णय हो जनहितकारी सेवा का भाव लिए मन में सत्कर्म सदा करते जयति जय सत्यमेव जयते जयति जय सत्यमेव जयते जयति जय सत्यमेव जयते जयति जय सत्यमेव जयते अनुशासित संस्कारित सुखिता है छात्रों की प्रतिभा दाता राही विधि विश्वविद्यालय से BBRL लॉ यूनिवर्सिटी से गर्वित होगी भारत माता अर्जित सारे गुण अर्पित कर वंदन माँ का करते जयति जय सत्यमेव जयते जयति जय सत्यमेव जयते जयति जय सत्यमेव जयते जयति जय सत्यमेव जयते अन्याय टले शुभ न्याय मिले अन्याय टले ओ सत्यमेव जयते जयति जय सत्यमेव जयते जयति जय सत्यमेव
Thank you so much. Our esteemed university, Dr. B.R. Ambedkar National Law University, Sonepat, was established by the Government of Haryana in year 2012 under the Haryana State Legislature Act Number 15 of 2012. The university has its campus in Rajiv Gandhi Educational City, Rai, Sonepat. Dr. B.R. Ambedkar National Law University is the only national law university in Haryana whose location provides a positive environment for legal education and professional training besides the overall development of students. The university has firmly resolved to impart advanced legal education to hone practical legal skills and interdisciplinary understanding, keeping in view the requirements of a just and equitable society. Talking about today's webinar, which is organized in the wake of 75th Azadi Ka Amrit Mahotsav on recent judgment on Section 377 of Indian Penal Code, a case of transformative constitutionalism for the scholars of a recognized university. This webinar intends to have conversations over such a shift in adjudication of indigenous morality and will enhance the understanding of transformative constitutionalism in India, and how all these are used as a tool in adjudging fundamental rights with special reference to the recent judgment of Honorable Supreme Court of India. This event will commence with the address from our keynote speaker, which will be followed by a question and answer session. Now I would like to hand over the mic to Sanchita.
Thank you, Shivani. Please confirm if I am audible.
Yes, Sanchita, you're audible.
Thank you, Shivani. We are very honored to conduct this workshop today under the able guidance of our Honorable Professor Dr. Vinay Kapoor Mehra Ma'am, Honorable Vice Chancellor of Dr. B.R. Ambedkar National Law University, Sonepat. Ma'am is an expert on women's issues, family law, human rights. And ma'am has also various research papers in numerous fields in her name. Ma'am has been awarded by various national and international commissions, and our Honorable VC Ma'am has previously worked as State Information Commissioner of Punjab. And I must say, Ma'am is the guiding light and the ideal motivation for entire PBRNLU family. Today, we are very elated to have the keynote speaker for the webinar, Dr. Debasis Poddar Sir, Professor of Law at National Law University and Judicial Academy, Assam. Besides PhD, MPhil in Law, and LLM, Sir was awarded MA in 3 social studies subjects. Sir has 80-odd pieces of publications to his credit, including those published in several flagship journals of national law universities. Sir was awarded a fellowship by the International Labour Organization for his visit to the International Training Center in the Italian Republic. Sir, as we all are eagerly looking forward for this informative session, I request you to please begin. Sir, please.
Thank you, Sanchita. Very good morning to one and all present here. At first, few words, introductory words I wish to share with you that first and foremost, I am very much impressed with this anthem, institutional anthem. It is a big takeaway for me. That is, I will remember this as one of the best practices among the national law schools I have ever seen. So in lucid language, the way it is prepared, I'm really, really impressed. And all of us should think over that this practice should be universalized across the law schools. So my sincere thanks to you for this idea. This is taken from my side. Second, my sincere thanks to Professor Mehra Madam, my senior colleague, that I got this opportunity to share my ideas and opinions over this issue, which is very topical. Also, my sincere thanks to Dr. Vinay Kapoor, who actually invited me to this session. Also, I remember my former colleague who introduced me to you. So with all these, I am starting my session. Today I am little
Thank you so much, sir, for accepting the invite and taking your time from your busy schedule and coming here on this platform and enlightening students on the topic. We are very much, and it's our most humble and sincere our gratitude we present here, and we hope that students will get to know more things about the theme of today's topic, sir. Thank you so much, sir.
Thanks, madam. It is actually a two-way process that when we speak to other forum, we also learn. Because nowadays these students, this generation of students, they are good in questioning. So questioning, it is very favorite to me, because within this questioning, within the word question, what I find is quest, which is the root word. So quest means quest for knowledge, quest for truth. So in that way, I am waiting for the questionnaire session after my deliberation, which will be real takeaway from my side also. Now, so far as transformative constitution is concerned, here I will divide my deliberation in two parts. First part is related to the constitution, constitutionalism, and obviously transformative constitutionalism. Second part, I will come into the judgment part. So first, I am trying to draw a background information, and thereafter, in the light of that background information, I will be speaking about the judgment, my opinion, ideas, observations. Also, last yet not the least, I wish to make a comparative study between the Navtej Singh case and Sabarimala case, which I just wanted to introduce a debate that whether or how far transformative constitution, the way it is spoken about nowadays, whether there is any flip side also. So from that comparative study of these two judgments, I wish to unfold a debate. I wish that students of NLU Haryana will take part in this debate. So let us start with this transformative constitutionalism. So rather than transformative constitutionalism, I wish to start this deliberation with constitutionalism. By constitutionalism, all the students, as student of law, I understand that constitutionalism is the principle on which the entire constitutional government stands. Constitutionalism speaks about the supremacy of the constitution and the rule of law, and all the institutions, all other laws for the time being in force, these are subject to the constitution, the provisions of the constitution. So constitution is supreme, and no other authority, whether it is individual or any other law for the time being in force or judgment, can exceed the constitution. Now, in that way, here sometimes the network gets poor. In case if it is disturbed, in that case, I request any one of you to kindly ring so that I will be able to understand. And another practice, I will prefer that if any one of you may please remain in the camera, because in that case I will understand that net is working if it is agreeable. Any one of you. So yes, in that case I can confirm my availability of net. So constitutionalism is something about the supremacy of the constitution, but at the same point of time, constitutionalism has one very long-term problem which constitutionalism could not address so far, that a particular constitution may be made a particular point of time, but thereafter, how long this constitution will work? This is a million-dollar question that, say, for example, Constitution of India started its journey 1950 onwards, some part 1949, 26 November, the rest of the part, the 1950, 26 January onward. But how long? Will it go for 1 million year or 10,000 year or 1,000 year or like that? That is with highest respect to our fundamental law of the land. This is an academic debate that, say, for example, U.S. Constitution, it has crossed 200 years, but how long it will sustain? British Constitution, it is unwritten constitution. It is going well for several centuries, but how long? So there are, in the world history, we have seen that there are several constitutions across the world which has been dropped also at several point of time. Like if you take the example of our neighboring state, People's Republic of China. People's Republic of China changed its whole constitution for twice in last 100 years. Why 100? It is 1948 onwards. So by and large, we are contemporary. So in that way, PRC is one example. There is another example of that is USSR, earlier Soviet Union. Soviet Union during its lifetime of 72 years changed the entire constitution 3 times. So there are other examples also across the world scattered, not many, but there are several examples that where the entire constitution has been replaced by another constitution. The rationale lies here that constitution, it is a social document of a particular time and space. Say, for example, Hitler, Germany. At that point of time, Hitler made several new laws. So Hitler constitution was dropped after the World War II. So in that way, you will find that there is question of existential question about constitutionalism, that constitution for how long? So there is no answer in the constitution book usually across the world. But at the same point of time, in last 100 years, we have seen that there are several practices across the world by which the old constitution got renewed. I repeat that across the world, there are several means and methods by which countries have renewed their constitution. So fundamental law of the land also is subject to amendability. As you can understand that in last 70 years are over, we have changed our constitution 100 times, more than 100 times. That is the amendment. If you take the number of amendments, you will find that umpteen number of changes, I think more than 100 amendments have taken place in last 70 years of the constitutional journey. Now, if you take care of these constitutional amendments, this is actually in a way or other to keep the constitution contextualized, to keep pace with time, because time is changing very fast. Especially last 30 years, we have seen the changes, the way it is a fast changing world, by-courtesy digitalization, etc. So you will find that nowadays change is getting very fast. So law needs to keep pace with the changing time, because law is time specific, law is space specific also. I can give you one example that monogamy. Monogamy is the norm in India. But there are several countries where you will find that monogamy, polygamy is allowed. Similarly, abortion. Abortion in the liberal democratic settings, these are allowed, but a few years back, there was a newspaper news headlines that in Ireland, one lady doctor, Indian lady doctor, was allowed to die because abortion is illegal. So in that way, you will find that law is not something universal. Law is changed. Sometimes law takes U-turn with the variety of regions. So in some cases, you will find adultery is earlier adultery was offense. Now adultery is not offense. Earlier, or I can give you more philosophical point that killing of man by man is a homicide. So it is crime. So across the country and across the world, it is crime. But at the same point of time, if you think of a battlefield, in battlefield, killing of man by man, it is not crime. Rather, on the contrary, it is act of gallantry. So the person will be prized, the person will be respected. That because context changes. So within the society and during peacetime and across the society, when societies are actually fighting for existence, with the change of situation, you will find even the act of killing also may get glorified, forget punishment. So in that way, what I am trying to flag off is this, that law is not something very static. Law also needs change. Say, for example, if very recently for a few semester I was offering Hindu law. So in Hindu law, then that is I read it 20 years back. Now, when I started offering Hindu law in this side of the desk, so I somehow I developed my jurisprudential understanding from this experience of taking classes. That look how the law can change. That up to 1954, polygamy was allowed in Hindu society. I repeat, up to 1954, polygamy was allowed in Hindu society because at that point of time, the entire Hindu society used to be governed by custom. Even in Hindu Marriage Act, it is repeatedly written that if you read Mulla on Hindu law, Main on Hindu law, Raghavacharya on Hindu law, you will find that it is a very clear position, settled law of the land, that in case legislation is silent, in that case, custom will prevail as law of the land. Because pre-1955 situation, say for example, Hindu marriage, it used to be governed by custom. And by that custom, you will find that Hindu society was, polygamy was allowed in Hindu society since time immemorial. Father of Rama had 3 wives. So in that way, but with the passage of time, the morality, the social morality, social yardstick, also the perception of state, public perception was changed. With the result that when B.R. Ambedkar was drafting Hindu Marriage Act, Hindu Code, at that point of time, the monogamy was insisted. Consequently, under Section 5 of the Hindu Marriage Act 1955, you will find that a person is eligible to be married if there is no spouse living. So it is just the pendulum went from one extreme to another. That is 1954, polygamy is allowed in this Indian Hindu society. 1955, polygamy is prohibited. So by one stroke of legislation, you see the pendulum went to another side. That is Hindu code or Hindu, especially Hindu Marriage Act, I find that it is a revolution. It is a revolution in the sense that B.R. Ambedkar, time and again, told that constitution must be a document of social revolution. And when he was drafting, that is, the entire Hindu code was drafted by B.R. Ambedkar, the first Law Minister of India. So B.R. Ambedkar actually practiced it, that a Hindu Marriage Act is actually a revolution, that from polygamy to monogamy, for the first time in the history of Indian civilization, there is no bar of marriage so far as caste is concerned. So if you again, I am reading section 5 of the Hindu Marriage Act 1955, between any two Hindus, that is, here caste is no bar, but yes, religion is bar, because any two Hindus. So for that, the same old man Ambedkar has already introduced in 1954 the Special Marriage Act, which is a secular law of marriage. You will find that different laws. So in case of constitution, I am trying to flag up the same theory in constitutional region, that in case of constitution, same things happen. That is, constitution also needs to be changed, because 1946 to 1949, the entire duration of the drafting of the constitution in the post-war world, where was the concern for environment, say for instance, because time was not ripe for provisions on environment. So Professor Upendra Bakshi used to tell that our constitution was environmentally blind. So there is no, though from Article 47 of the Constitution, tangentially environment is coming, but you will find that original Constitution was environment blind. But at later point of time, environment was introduced because international development, etc. I'm not going into details, but the way Constitution introduced this environmental concern, how it is introduced? It is introduced by the 42nd Amendment Act 1976, that is 48A. Article 48A was introduced. At later point of time, by judicial interpretation also, it was decided by the Apex Court that right to environment is part of life. So in that way, it is coming, but you will find that original constitution was silent about environment. Original constitution was silent about intellectual property also. But now intellectual property dimension may be deciphered from right to property, because right to property, it may be interpreted as including intellectual property, because concept of property. So in that way, I am trying to flag off one very simple point, that no law is perfect, no law can stand the test of time for a very, very long time, centuries, millennium. Do you think that our constitution is indeed a great masterpiece? I am fond of this. I am reading this constitution for last 32 years, 33 years. Now, do you think that this constitution, if we keep it as it is today, can it address the problems of maybe 2121 after 100 years? You will find that is, you can imagine that it is a different world. We will not be there. Our reality will not be there. A different reality. Our reality will be replaced by a different reality. Who thought about cordless phone, that is mobile phone, even before 30 years? Even before 30 years, how many household people had phone, landline set? So in that way, the world is very, very fast changing. How to address these changes? I will take care of another type of change, that is regime change. Say, for example, just touching upon this issue, that there is one case which during research I came across, that grudged informer case in the Weimar Republic, that is the republic established by Adolf Hitler. So grudge informer case is based upon a law duly enacted in the parliament by Hitler that in case if there is any comment, any statement against Führer is the president, Hitler. So in case if there is any negative statement about the regime, about the Führer, that's president of the Weimar Republic, in that case, it will be a punishable offense and it will be punished by death. That is, negative remark about the head of the state will attract death. Now, draft informal case was based on that statutory provision, and one wife, husband was a police officer and basically intelligence officer, and in private capacity within the home space, he shared some dissent about the Hitler regime. And somehow the relationship between husband-wife spousal relationship was not good. Somehow this comment was made in the house setting, the domestic settings only shared with wife, and since spousal relation was not good, so sometimes spouse may be impossible. So spouse has taken it to the police station, filed a complaint that her husband has made this comment. And on the basis of that, the intelligence officer was tried, and ultimately he was executed. Now it happened thereafter, after several years, Second World War is over. Thereafter, this matter was again revived by another person, relative of husband. And this time German court decided the matter against the wife. This time German court decided the matter against the wife on the basis of betrayal to the spousal relations, and also betrayal to privacy rights, etc. That is, husband's privacy was breached by the wife, and also betrayal to the spousal relation, betrayal to marriage. So this judgment was criticized at several levels, especially positivists like Professor Hart, etc. But another lobby, well, by now it is a celebrated judgment. And the judgment, what do you think? That this judgment is good or bad? Yes. Can you respond? Is it a good judgment or bad judgment? So somehow this judgment of the German court in the post-World War, this was celebrated at that point of time. Still now it is by and large held good judgment, because essentially here, if you Madam Vinith Madam must have taught you that Hart-Fuller debate, etc. So here, actually German court at that point of time, though Hart-Fuller debate took place at a later point of time, but German court actually invited the principle at that point of time, not articulated, but the principle of the inner morality of law. So inner morality of law is something which is the core of today's deliberation, what I am delivering right now. The transformative constitution, it actually examines the constitutional morality from time to time, because time is changing very, very fast. And with the change of time, society also is changing very, very fast. So with this changing time, how to cope with the public standard of justice, etc. These are the questions. So I am coming into the Indian experiment that in India you will find that during late 70s onwards, it happened up to 90s. Nowadays you will find public interest litigation we hardly hear about nowadays. So it is not because public interest litigation is not taking place, but at that point of time, the public enthusiasm about the public interest litigation, it is now little down. Now, so far as public interest litigation is concerned, it is actually the predecessor of transformative constitutionalism. It is actually the predecessor of transformative constitutionalism in the sense that in the original constitution, the Supreme Court found that something is lacking. Something cannot be addressed by what is written in the original constitution. That is this abject poverty, exploitation, extreme inequality of income. Some people are living a wretched life without fault of their own, maybe police atrocity, etc., or governance failure. How to address? So, if you take care of the written laws, written provisions of the Constitution, it is very, very difficult to address within the written provisions of the Constitution. Now, here, the Supreme Court introduced public interest litigation. Now, here there is a larger question: is public interest litigation constitutional? Now, I understand that I will be a bad boy if I ask, but take it academically. Can Supreme Court, which is a creature of the Constitution, introduce something which is not at all written in the Constitution? Can it do it reasonably or legally? So public interest litigation, it is nowhere written in any provisions of the Constitution, including the schedule. Is it a right statement? You may participate. Yes, Shivani, is it a right statement that public interest litigation, introduction of the public interest litigation, it is not endorsed by the Constitution anyway? I find there is a source. I find there is a source in Article 142 of the Constitution. In Article 142, you will find reference of complete justice. So, that is, as a keeper of the Constitution, as guardian of the Constitution, Supreme Court can do something residual, which is not mentioned. But it is mentioned in Article 142 that Supreme Court has that residual power to attain complete justice. So, Indian Constitution does not talk about justice, social, economic, political. Indian Constitution speaks about complete justice also. So, in the interest of complete justice, I find that public interest litigation has its endorsement here. Now, public interest litigation, as I mentioned, that it is, I find that it is actually predecessor of transformative constitutionalism in the sense that is transformative constitutionalism, the way 2014 onwards we speak about. That was actually practiced by PIL. PIL is the predecessor of transformative constitutionalism because the apex court wanted to transform the society. Now, from where this transformation, the idea of transformation is coming? Again, I will go back to B.R. Ambedkar, who repeatedly mentioned that Constitution is not only fundamental law of the land, but Constitution is a document of social revolution. So, social revolution, it can be channelized only through social transformation. So, in that way, if you find that you will find that this PIL is actually the earliest practice of transformative constitutionalism, that is going beyond the written law of the land, even if it is fundamental law of the land, going beyond fundamental law of the land, traversing beyond fundamental of the land. This is for the first time this was taught by V.R. Krishna Iyer, P.N. Bhagavati, etc. in way back in late 70s through PIL. But there is a fundamental difference between PIL and transformative constitution. That is, if you take 1977 as the starting point, P.N. Bhagavati, V.R. Krishna, they are starting in their judgment this type of practice, sitting in the courtroom, actually going beyond the courtroom, going to the grassroots, from the courtroom to the grassroots. They are coming beyond the courtroom. So this practice, this is actually the first instance of transformative constitutionalism. But PIL, in a way, it is there is a fundamental difference between PIL and today's transformative constitutionalism, in the sense that in the PIL experiment, Supreme Court experimented with procedural matters. That is, the Supreme Court came out with the argument that this locus standi matter will be diluted, as you know. But that is essentially procedural. That is, entire public interest litigation discourse was revolving around the procedural trope, which Supreme Court wanted to get rid of. But transformative constitutionalism 2014 onwards, the way it is in the frame, now you will find that there is a fundamental change in this approach. This is also transformative constitutionalism. Actually, it is the next step after PIL to cope with the changing time, because Constitution is getting aged. Constitution is going towards 70. Now Constitution crossed 70. So aged Constitution, or in a way matured Constitution, it needs some support. So transformative constitutionalism is a support, and it differs from PIL in the sense that transformative constitutionalism experiments with substantive law. I repeat, PIL experimented with the procedural law. Transformative constitution is experimenting with the substantive law. That is, now here Supreme Court has taken the idea of interpretation. That is, if you take recourse to a very, very different interpretation of the same law, you will get a new law. I hope you are getting the point. I debate that in case if you change the interpretation of the same law, what you will get is a new law. Exactly, I am going back to this grudged informer case of the Weimar Republic. In the Weimar Republic, husband was executed for a statutory offense, but at later point of time, wife was convicted. Wife was convicted because now interpretation took a U-turn. I hope you are getting the point. That is, since interpretation took a U-turn, that is why you will find that Weimar Republic Court punished husband with death, and the post-war German court punished the wife for betrayal, because meanwhile interpretation of the law took a U-turn, because now post-war German court is of opinion that the statutory law was devoid of morality. So at later point of time in 1958, we will see Professor Fuller is introducing the inner morality of law and the 8-year states. You must have read the Hart-Fuller debate, etc. So inner morality of law is something which at later point of time, if you take PIL, if you take this transformative constitutionalism, actually what is functional is the inner morality of law. That is, Supreme Court is appreciating the change time that 1950 India is a very different India. 2020 India, that is after 70 years, now fundamental law also needs to be changed. Now question is that, do we need a new constitution? Do we need a new constitution? I repeat. Actually, I am quoting exactly the book of Justice B.L. Hansaria. B.L. Hansaria wrote a book published by Eastern Law House, Kolkata, that do we need a new constitution? So one option is let us replace this constitution by another constitution. This is one option. I don't know whether it may be an option, but in the given situation of the country, policymakers, at least Apex Court, thought to bring in change, the change which is required, because 70 years are past. 1950 India, that is, constitution is lagging behind to keep pace with the changing time, fast changing time, globalized world. Now, actually, Supreme Court has evolved to cope with the fast changing time. At first with the PIL, that is in the last century, and now recently with this transformative constitutionalism. As I told, that PIL is a technique or experiment through change of the procedural part. But transformative constitutionalism, it is another technique, another judicial policy making to cope with the fast changing time with newer interpretation of the constitution. And here, these judgments, plethora of judgments are coming. Naftaj is one of them. Sabarimala is another. Now here, now I am entering into the second part of my deliberation, that is judgment part. So transformative constitutionalism and constitutional morality. So far as constitutional morality is concerned, I need to spend some time. That if you think that constitutional morality, that is usually common man's perception is that constitutional morality is morality of the constitution, not like that. Let it be very clear. That is, it is not constitutional morality. In that case, Supreme Court could have told that morality of the constitution. Constitutional morality and morality of the constitution, there are overlaps, but they are not the same. They are similar. Similarities are there. Overlaps are there. But constitutional morality and morality of the constitution, these are not interchangeable. There is technical difference. Technical difference lies here that morality of the constitution speaks about the morality which is reflected through reading of the letters of the law. That is morality of the constitution. Constitutional morality, it is something different. It actually reflects upon the inner morality of the constitution. That is, here I am not speaking about Constitution of India as a piece, as a document. This Article 1, 2, 3, 95 and followed by 12 schedules, not this constitution. Now, if you dig deeper, what is constitution? I am not speaking about Constitution of India. What is constitution? Say, for example, before 1950, before 1949, was there any constitution? If you read legal and constitutional history of MP Jain, etc., you will find that there were predecessors. Predecessors were there like Government of India Act 1935, Government of India Act 1919, Government of India Act 1858. Before that, say for example, in the Mughal Empire, in the Pathan Empire, in the earlier Hindu Empire, even before that Vedic age, was not there any constitution? Is constitution only a written document by the Constituent Assembly, endorsed? I guess it is not. Say, for example, if you read the way I have read family law, especially Hindu law, I find that ancient India, constitution was there in ancient Indian law also. In ancient India, constitution was dharma, if I take. Constitution may not be a written document. There is contemporary legacy also. The legacy we have inherited also. British constitution is not a written document. There is no written constitution in Britain, but British constitution is the oldest constitution of the world. So constitution may not be a very tightly written document endorsed, assembly, this, that. It may not be. Constitution may be governed by custom, tradition, the unwritten constitution of England. Constitution may be several principles also, a code of conduct, like dharma is a code of conduct, unwritten law of ancient India, but that was also constitution. So transformative constitution, here you will find, I'm coming back, that transformative constitution actually reflects the changed constitutional morality. I repeat that morality of the constitution and constitutional morality, they are not same. Constitutional morality is the inner morality of the territory and its people, the public conscience. If you remember Savini, historical jurisprudence, that holds case, the idea of holds case, that is public conscience, the holds case in German word. So that is also constitution. What hurts constitution, what hurts the inner conscience of the constitutional tradition, that is also something to be done away with. So transformative constitutionalism, through the introduction of constitutional morality, which is not morality of the constitution, it actually it is designed by the apex court to take the constitutional governance further. Wherever constitution is lacking, they are to interpret constitution differently. That is, nowadays you will say inclusive constitution if you take the Navtej case. But here I am coming to Navtej case. For some time thereafter I will go for the comparative study between Navtej and Sabarimala. That is, I am actually interested to unfold that comparative study. But before that, since this is the mandate of my deliberation, I am entering into the Navtej case. Now, in Navtej case, actually a colonial provision or colonial concept rather than provision. That is, if you read section 377, same sex, etc., nothing has been mentioned. If you read section 377, there is no explicit reference of same sex. But it is construed, that is from the very beginning, from the colonial era, that same-sex, the sexual intercourse between two persons with same gender, it is an offense. Now, I am trying to dig a little deeper on this point. Who told that the intercourse between similar same sex is offensive? Who told? That is, at least so far as my reading goes, it was not there in Indian tradition. It was not there in Indian tradition. If you take a cue from mythology, in mythology, I very well remember that mythology is very clear. Ancient Indian mythology is very clear about this, that God created all. God created every human being of every type, and God created the nature other animals, everything is created by God. If you take, if you want to understand this criminality, origin of criminality, you need to go beyond. Remember that this is actually getting drafted by Lord Macaulay. So he took you to, that is, as far as my reading is concerned, he took you from his own tradition, that is Christianity. If you take the Christian mythology, you will find that God created only two types of human being. One is Adam and another is Eve. So here in the Christian mythology, you will find that creation is getting stereotyped. Creation is getting stereotyped with a binary opposite, that either the creature will be male, that is Adam, or the creature will be female, that is Eve. And also, today's gender politics, today's patriarchy, you will find that it is very much there. If you read Milton's Paradise Lost, you will find who consumed the forbidden apple for the first time. It is not Adam, it is Eve. So from the very beginning, if I take Christian, the mythology as the beginning of the civilization, this stereotypical positioning, that is positing the female as other sex, which is inferior in terms of intellectual standard. It is driven by emotion, not reason. Adam is the repository of emotion, wisdom. Adam is actually sacrificing his immortality for Eve. So Adam is also consuming the forbidden fruit. So that is Christian mythology, and I am not condemning, but this stereotyping the gender, stereotyping the salient features of the specific gender, I find, as a student of literature, I find that it is very much there since time immemorial. That is ancient ancient European mythology speaks about this. Whereas in Hindu mythology, I find that God is creator of every possible creature. So in that way, you will find that when Lord Macaulay is criminalizing this, and followed by the European judges, that intercourse between same sex, it is criminalized. In Hindu, that is, I am taking again cue from Mahabharata, that in Mahabharata you will find a character called Brihan. So Arjun, a prince, went to the extent of taking cue, that is during his exile with anonymity. Arjun accepted, Arjun being a prince, son of a king, very well accepted the role of a eunuch, Brihanala. And Brihanala, in this role, Arjun was accepted by the king to the extent that king's daughter used to learn music and dance from Brihanala. So, that is, I'm trying to flag out this point, that even in ancient India, if I take literature, if I take the epics as the reflection of the then society, you will find Brihanala was not outcast. Brihanala was not done away with from the society. He was taken by the king's court for teaching king's daughters. So the means of livelihood of LGBT community, if I take Brihanala as an icon, it was accepted in India. Whereas today, even today, as on date, I find that that is, nowadays things are changing, but until recently, LGBT community had no means or right to livelihood. They were roaming around here and there and begging. So now very slowly situation is changing. But how situation has changed? Nowadays judgment played a critical role. So this judgment took you from transformative constitutionalism. Transformative constitutionalism, to my understanding, it is not mentioned, but legacy has a role here. That is ultimately, if you read Richard Posner's celebrated book, How Judges Think, that is in the subconscious mind of the judges, great judges, many things they interplay with one another. History is one of them. History, our tradition, mythology, their understanding, because we are also, that is every human being like me, madam, you people, we are programmed, that is artificial, we are living in the age of artificial intelligence. Who knows that we are not a product of artificial intelligence by a superpower, by a super entity named God, maybe. So the way today there are many atheists, atheism is modernity, it is thought of. So who knows that after 100 years or 2000 years, this product of artificial intelligence robot may defy us, whereas we are creators of robots. But at a later point of time, after down the line, there may be a day when robots will defy us. No, you did not create us. So artificial intelligence may transcend the level of understanding and appreciation of their reality in their own way. So truth is one or truth is many. If you read the Yugoslav political philosopher Kierkegaard, Kierkegaard. Now Kierkegaard has introduced for the first time in the history of civilization that plurality of truth. Now, without Kierkegaard, you cannot justify secularism, Indian secularism. That is, if truth is not plural, then only one type of God imaginable we imagine. That is, in that case, communal harmony cannot be attained without Kierkegaard. So that is, there are many things, but I will not dilute the matter. So let us go back to the Naftage case. So in Naftage case, transformative constitutionalism, in the name of transformative constitutionalism, I find that judges are back to the first 5 words of the Constitution. We, the people of India. Now, we, the people of India, this is so inclusive expression, so inclusive. We, the people of India, don't you think that it includes this LGBT, everybody, male, female? So in that way, that we are actually back to Indian mythology, that God, whoever is created by God, everyone is part of the society. It is an inclusive society. Hindu society is an inclusive society since time immemorial. It has actually internalized the otherwise outsiders also. It internalized our invaders. That is, we take that is Hindus, whether we are Hindus or not, whether Hindus are original inhabitants, because if you read Indian anthropology, you will find that original inhabitants of these subcontinents are tribes. Aryans were invaders. At later point, Aryans were transformed into Hindus. Hinduism in loose sense of the term. Thereafter Islam, thereafter Christianity, Portuguese. So this land internalized even outsiders. Who knows that we are not outsiders? But there is a difference between Hindus, Muslims in one side and Christians on the other. Not Christians, but colonizers on the other, because colonizers, British Empire, British government, British subjects, when they colonized us, they consciously kept distance from this country and countrymen, the way it happened for Aryans. That is, Aryans invaded, thereafter they did not go back. They assimilated within the society, they accepted the society as the society of their own, they remained and they merged with the society. Muslims, albeit arguably, but it is, to my mind, mainstream Muslim community also marched. But that did not take place for colonizers. Colonizers kept a very conscious effort to keep them separated. That is why ultimately colonizers went back. Colonizers left India. Quite unlike other invaders. Aryans were also invaders. Muslims were also invaders, but they did not return. They got merged with the society. So in that way, you will find that I am trying to pinpoint this truth, that when we actually talked about the Constitution, first 5 words, we the people of India, I find that we the people of India includes, it is a very inclusive expression which includes the other sexual orientation, people with other sexual orientation also. So actually here lies the constitutional morality which by this exercise of transformative constitutionalism, in this occasion of this case, Supreme Court has attained, and it is a very welcome judgment. Remember that Navtej is a unanimous judgment. That is, there is no dissenting on it. Now I will come to the third and last part of my deliberation, that is a comparative study between Navtej and Sovereign. Now, in this part, I will try to flag off one flip side of transformative constitutionalism, because no theory is foolproof. No theory is foolproof. Transformative constitutionalism has a problem that nowadays the new generation judges, this is an academic discussion, take it likewise. Nowadays, the way new generation judges, most of the new generation judges have accepted the Western parameters, Western paradigm as the universal paradigm. There is a problem. And the problem is unfolded by Sabarimala. In Sabarimala, as all of us know, that it is a divided judgment. Unlike Navtej, Navtej is a unanimous judgment. Sabarimala is a divided judgment. In Sabarimala, the judgment was given on the basis of 4:1. So 4 male judges, I count this, in one side they made the judgment, and the dissenting opinion was delivered by the only female judge of that bench, Justice Indu Mahotsav. That is, I find that it is something to be noted. So Sabarimala, which is all about the women rights, the only female judge of the bench issued dissenting opinion, and against the judgment, that is right to access of women to the table. Now, I find that if you compare between Navtej and Sabarimala, you will find that Navtej and Sabarimala, there are similarities, there are dissimilarities. Similarities lies here that in Navtej, it is the question of basic human rights, right to live for these people with other sexual orientation, sexual minority. Now, here it is an altogether different case from access to women, that is right of women in Sabarimala case and right of LGBT in Navtej case, though the judgment has taken both of them as right, human right, but I find there is a fundamental difference between right of LGBT community in Navtej case and right of women in the Sabarimala case. Difference lies here that human rights, if you remember the fundamental definition of human rights from Universal Declaration of Human Rights 1948, you will find that human rights is something very basic. I quote from UDHN 1948. Human rights definition, human rights is defined in that way, something very basic and inalienable from the human person. So LGBT rights in Navtej case is actually fitting into the UDHR definition, classical definition, that it is very, very basic right and something inalienable, without which they cannot live. But human rights of women in Sabarimala case is very, very different. That is, if you take the touchstone of basic, is it basic? That is take it academically. Don't be driven by your identity as male or female. Take it as academic discourse that without access to Sabarimala temple, is it basic in the sense that is it something without which a woman cannot live? So this is a very, very, very fundamental point I am trying to flag off, that there is a fundamental difference between LGBT rights in Navtej case and the women rights in Sabarimala case. It is more, there is, in Sabarimala judgment, I find that there is power quotient, equal status and opportunity. But equal status and opportunity, if you read preamble, equality before the law and opportunity, equal opportunity. If you take Article 30, that is equal, in DPSP also it is written that equality of status and opportunity. So equality of status and opportunity, it is actually driven by liberal politics of feminism. That is, feminism also have several groupings: liberal feminism, radical feminism, racial black feminism, so continental feminism, postmodern feminism. Feminism is of a that is, with humor. I remember that there is a say that how many feminisms are there? The answer is this is equal to the number of women. So like that, that is, there are umpteen variety of feminism, and at times one variety of feminism actually it stands at loggerheads with another variety of feminism, like liberal feminism and radical feminism. If you read that jurisprudence book from ancient Greece to the present, you will find that there is a long debate, long pending debate, which is still unsettled between liberal feminism and radical feminism. So I'm trying to flag off this basic point that in Sabarimala, the women rights, it is actually not qualifying the test of UDHR definition. That is, neither it is basic inalienable rights, that is, without this, that is, if there is no access for women to Sabarimala, the woman will die. Not like that. That is, there is a qualitative difference between LGBT rights in Navtej and women rights in Sabarimala. So that is, I am not against women rights, but that is, don't get prejudiced against that is, I am taking only this context, that entry to women, and Justice Indu Malhotra being the only female judge of that bench, I find that she has good points that though it is not law of the land, because 4 male judges, that is, though it cannot be identified as male female, but it matters. People count. So in that way, that stereotypical rights jurisprudence actually Justice Malhotra, I appreciate that she differed. She could differ. That is the main point, legal point, where Justice Nariman, Justice Mishra, they conquered that they took the Sabarimala temple priesthood as not as a denomination. Indu Malhotra took this as a denomination. That is, religion is something and religious denomination is something else. These 4 male judges, they are driven by that original section 5 of Hindu Marriage Act argument that Hindu includes Sikh, Buddhist, Jains, Virashaivas, that is, there are several sects of Hinduism all taken together under the Hindu Marriage Act or Hindu law. The same argument actually that jurisprudence was continued in the viewpoint of these 4 judges. But Justice Indu Malhotra differed, and I find that very rightly differed. The denomination is something different from sect. That is, so far as a particular temple, that is, if they contended that women has no right to access to any temple, that is different. But in a particular temple, women access from this age to that age. So it is a matter of religious belief and religious practice. I am not going into the details of sections of the Kerala Act, but this practice, it is also a matter of right to practice religion, right to profess religion by other people. So in that way, I find that the way there is a stereotypical trend followed by transformative constitutionalism, in the name of transformative constitutionalism, the way there is a very stereotypical trend that all rights are same. So really, any bar to access, it is regressive, and progressive is access. Progressive is right. So here I find that this is the flip side of transformative constitutionalism. Transformation, in the anxiety of transformation, the original ethos, original tradition of the wonderful country called India, that should not be tinkered with. I am consciously using this word tinkered. That is, religion. Actually, if you take the original meaning of secularism, in that case, secular state does not recognize any religion. But in Indian dimension, secularism means equidistance from all religion. So this is one part. In public domain, state may observe equidistance from all religions, but here in Sabarimala judgment, the majority opinion or judgment, that has actually entered into the internal affairs of religion, which is an institution in itself. Here I find that the judgment that is dissent is also valid right in a democratic country. So in democratic governance, dissent is right. Justice Indu Malhotra dissented, and I also found that the minority opinion is qualitatively better than the way in habeas corpus judgment. Remember Shivakant Shukla judgment, Justice H.R. Khanna's minority opinion, it was actually celebrated, and not the majority judgment. Rather than that, H.R. Khanna's minority opinion that in the habeas corpus case, in those dark days, that is still celebrated. So in that way, you will, I beg to submit before this August House, because you people will be the next generation citizen and the next generation lawyers also. So I find that the quality of reasoning, it may be adjusted at later point of time. The quality of reasoning, because law is art, judgment is ultimately all about reasoning. So I find that quality of reasoning is better in Justice Hindu Malhotra's minority opinion rather than. But yes, but I understand that the Supreme Court was anxious about affording women's right. Because, but I again, this argument is not put forward by Justice Malhotra, but I find that original UDHR test. On Sabrimala judgment reasoning, it is not qualifying the original UDHR test of human rights as basic and inalienable, without which human being will die. So not like, or live wretched life. Do you think that how many of you went to Sabrimala? That is, without entering into Sabrimala, women, that is, there may be a good life also. So here I end, because we are, I think I have taken sufficient time, and I wish to hear and take away from this session. And now this is time for me to take away. Yes, it's over. Thank you.
Thank you so much, sir. It was wonderful to hear you. I'm sure all our participants must have learned a lot today. Now, if anyone have any question, they may unmute themselves and ask, or they may put it in the chat box.
Don't be influenced by the formal words of Shivani. I welcome criticism, because we are in a democratic country. So feel free to differ. Feel free to differ, because dissent, democracy lies in dissent.
Good morning, sir. Saud here.
So, yes.
Yes, sir. So my question is that you talked about Sabrimala, of course, and before Sabrimala, there's this very important judgment, Bombay High Court, Narasu Appamani, right? So in the context of the entire issue of personal law and religious laws and etc., how do you see testing personal laws or religious laws on the basis of our modern day sensibilities? Like Justice, not Justice, Advocate Indira Jaising, she said that the ghost of Narasu has finally been exorcised by Sabrimala. So, like, what's your take on that?
Can you brief the Narasu judgment?
Sir, the Narasu Appamali judgment. Bombay High Court.
Have Bombay High Court judgment. They just brief the fact and decision.
Sir, I don't know, but it was held, like I know the judgment, that it was held that personal laws should not be examined on the basis of Article 13. And personal law is not law for the purposes of Article 13. Justice Chagla and Virendra Gadkar's judgment.
Okay, so usually I keep track of Supreme Court, but yes, if this is the thing, I agree with this. I really agree with this. But in Sabrimala, you will find that somehow what I like to differ is that here state is entering within the internal affairs of religion. Here I find problem. But here, as I mentioned repeatedly, that Justice Malhotra's minority opinion, it may be said that time is the ultimate test. So it may be celebrated at later point of time, the way in habeas corpus case, Justice Khanna will be remembered for habeas corpus case minority opinion. Sometimes, and this is a very good research topic also at later point of time. If any of you prefer higher education, if I am sure that some of you will join academics at later point of time, you may research on this matter, that minority opinion across these 70 years. So in many countries, minority, and in India also, definitely. Minority opinion, it is it is my area of research interest. Sometimes I find minority opinion makes much more sense than official position of Supreme Court sometimes. And at later point of time, Supreme Court accepted also. That is, in after emergency, Supreme Court is left with no other option but habeas corpus judgment was a problematic judgment. So at later point of time, who knows that Sabrimala judgment may not be reviewed. That is countrywide, you understand that there is a trend going on for last 7-8 years especially. So ultimately, I remember one wisdom that fact is established fiction. I repeat, fact is something that is there any fact that is, I doubt. Sometimes I think, I find, I came across these words. This is not my wisdom, but I remember and I appreciate this, that fact is established fiction. So at later point of time, this fiction, minority fiction, may be accepted by Supreme Court also, who knows? Because Supreme Court overruled its own judgments. Say, for example, I remember B.L. Hansadia's 1994 judgment that 309 was declared unconstitutional. That is, suicide was decriminalized. But after 2 years, another bench just not set aside, but it upheld the earlier position, 1996. So for 2 years, 1994 to 1996, 309, section 309 of Indian Penal Code was decriminalized. So it happens. That is, perspective or position may change from time to time. Yes, thanks.
All right, sir. Thank you so much.
So we have a question from Nikhil in our chat box. I'll read it out for you.
Yes, please.
The period of Justice Bhagwati and Justice V.R. Krishnan Iyer saw the rise of PIL and SLPs, which has now become an issue because maximum time of Monday and Friday is wasted in its admission, and in wake of transformation we have lost touch of our real constitutional values.
That is, as all of us can understand, being a law student, that the days of PIL is over. That is, PIL at later point of time, it was bitterly criticized. PIL was bitterly criticized on several counts, major counts I remember two. One is that when after paying the court fees, people are waiting for decades, and the judges are out of their own priorities. Judges are entertaining the cases without court fees in the name of PIL. So this is one. And while after giving court fees, which is huge, because Supreme Court fees, you can't imagine sometimes. So after paying court fees, people are waiting for decades, and without paying court fees, people are getting justice. So that is, if we take the equality standard, it is problem. Another is that, as all of us are aware, that sometimes, not always, but sometimes there were the people who filed public interest litigation just for the sake of name, reputation, to attract news headlines, etc. That also was very severely criticized by Supreme Court itself. And Supreme Court now changed its policy. Now accepting PIL is an exception. That is, during 70s, 80s, the way Nikhil mentioned rightly, that Justice P.N. Bhagwati, Justice V.R. Krishna made it a habit, with due respect to both of them. They made it a habit to entertain PIL, as if there is nothing else. But on these two counts, at later point of time, Supreme Court, I guess, took a conscious decision that they are now also the PIL is getting accepted, but it is a matter of exception, very, very sparing. But at that point of time, several judges, I'm not naming them, they made it a habit to entertain PIL. This every one postcard, one newspaper reading by judge himself, and it is converted to PIL. So excess has happened at that point of time, but now Supreme Court, High Courts also, it is a balanced approach. Present approach is a balanced approach that PIL should be exception. In the name of complete justice, you cannot indulge in complete justice only when after paying huge court fees, people are waiting for decades. So that matter is addressed. Now, transformative constitutionalism, it is actually experimenting with the substance of law to explore inner morality of law. So constitutional morality, not morality of the constitution, the way I explained already. Thanks, Nikhil.
So we have one more question in the chat box by Arun Srivastav.
Please.
What do you think is the extent to which the court can inquire into the issue of whether a particular practice is an integral part of the religion or religious practice of a particular religious denomination? Or should that be left exclusively to be determined by the head of the section of the religious group?
Undoubtedly, I appreciate. Great question and very, very relevant to my deliberation. This is exactly what I am trying to flag off. That see, if you go beyond law, if you will find that I am approaching this question from sociological perspective, as a social science student. That if you take sociology, even there is a passing reference in Article 38, 39 of the Constitution also. What is state? What is state all about? State is nothing but an institution. Now, if you take recourse to sociology, you will find that I'm sure that you people are reading sociology also. Here, sociology is being taught. So in sociology, the subject starts with this premise that family is the most primary institution of the society. State is another institution of the society. Religion is also another institution of the society. This is universal truth. There is no debate. There is no difference. Now, Justice Indu Mahotsav, obviously she is a learned judge and she put it effectively sitting in the bench, and from academics I find that this is a good reasoning that in Indian society, which is a plural society, which is following the liberal democratic discourse, here state is taking care of governance, national security, everything. So state has some hierarchy. In hierarchy, state is above, but unnecessarily state as another institution of the society, it should not tinker with the internal issues of religion, which is another institution of the society, family, which is another institution of society, until the practice is in gross violation of human rights. Say, for example, the very same person, Debasis Poddar, supports the talak judgment, whereas I find this Sabarimala judgment problematic. It is because within a plural society, within a society which is following liberal democratic governance, here state has its own hierarchy because it is actually assigned to take care of many very important issues like national security, like defense, like governance, like justice. I understand, but unnecessarily this within internal issue that in the southernmost tip of this vast country, there is a temple, only one temple, there whether access of a particular age group will be allowed or not, though it is public domain, I understand the law, but it is whether or how far it is very, very necessary or very, very urgent work of state. That is, if I remember the tort differentiation, that is sovereign function of state and non-sovereign function of state. Flying the bus is not sovereign function of the state, but policing is sovereign function of the state. So whether or how far ensuring access of a particular age group of women in a particular temple, not all temples. If all temples, there is definitely an issue. But in a particular temple, that is also all the way. How many of us visited Kerala in lifetime, or how many of us will visit Kerala in lifetime? I am from Bengal. How many of you will like to visit Bengal? If you don't visit Bengal, heaven will not fall on you. So this is whether it is required or desirable in the inner issues. Only one temple of a particular age group, there must be some religious reasoning. So state will do better if it does not tinker with the religious reasoning, which is internal. But this triple talaq judgment I support, because it is actually affecting the basic human rights of all women who are affected. It is affecting life, which is most precious for all of us. I love my life. Every one of us loves his or her lives. So in that way, it is something related to very, very basic human rights. But in case of Sabarimala matter, it is not happening like that. So here I am differentiating between this. The question is really brilliant, and actually I wanted to flag off this point. I must thank the person who, what is his name, Arun. Arun, my sincere thanks to you. You helped me to unfold the major issue, one major issue in details. Thanks.
So we have another question from Dheeraj. He asked, as we talked about Sabrimala judgment, isn't a fundamental right to equality an appropriate ground to provide women entry into the temple? It's not about if they would die if not allowed to enter the temple, as you said. It's about the rights that we profess as citizens, as per my opinion.
No, the Dheeraj, I am, that is, don't take me as an expert in constitution. I am also a student of constitution. You are also. But there is difference. I am reading 30 years, you are reading 3 years. So I am sharing my opinion. You have every right to differ. So kindly look into preamble, that is equality clause. You will find after justice, thereafter liberty, thereafter equality, thereafter fraternity. So here also just it is, I am deviating. So this sequence that liberty first, equality second, whether it is actually indication of driving a capitalist economy, this is a larger issue. But if we read liberty is followed by few words. Liberty of status and of opportunity, right? So here you will find that liberty of status and opportunity, actually liberty of status and opportunity before the law. So liberty in our country, unlike American Constitution, if you read the relevant provision counterpart of US Constitution, you will find liberty is very, very different. That is, our liberty is personal liberty. If you read Article 21, you will find that liberty is adjectivized by the word personal. So our liberty in India, liberty is always very guarded, because the tradition is different, regional tradition is different. Whereas in USA, liberty is unfolded. That is, in USA, citizens have right to carry arms. Citizens have right to carry arms in USA. Here, in our constitution or our Arms Act, it is different. Position is different. So, liberty of status and of opportunity. It is not. It is not unlimited liberty. That is, it is very restrained liberty. So, in that way, you will find that is liberty of status and even if you take equality clause is also very guarded. If you take equality clause under Article 14 of the Constitution, then also you will find equality before the law. It is not equality means it is not economic inequality. Economic, that is equality the way prima facie we presume that is it is economic equality. Everybody will have 10,000 rupees. Not like that. Equality before the law and equal protection of the laws. So here equality, I find the word is very confusing. Equality here, it is actually civil right. It is actually supplementing liberty. So in that way, equality is not, also I am directly answering Dheeraj in this question, in this sentence, that if you read Article 15, very, very important, that nobody should be discriminated on the basis of sex. There are other qualifiers also. So discrimination, whether it is discrimination, remember that I have already explained human rights from UDHR perspective, because that is the source. The human rights is not born in India. Human rights is not born in any country of the world. Human rights, it is coming from international jurisprudence. So UDHR qualifiers are very clear. Human rights must be very, very basic, fundamental, and human rights must be inalienable. So here is my argument. I am actually articulating another person's argument, the argument of Justice Malhotra. That is, entry to Sabarimala, it cannot pass the test of UDHR. UDHR test, it is not qualified. That is very, very basic. With if a woman cannot enter into the Sabarimala temple, she will die. It is not the case. So, but triple talaq, yes, because it is directly antithetical to the life and means of livelihood of the woman who is getting deserted by a women fancy of a person, of her spouse. So that is in our country, we are yet to transcend the level of classifying the rights. All rights are not human rights. Say, for example, do you think that intellectual property rights is human rights? It is commercial rights, isn't it? So Galileo, they invented telescope. Galileo did not patent it. So it is not, intellectual property rights is not human rights. So similarly, that is, since it is not qualifying the UDHR test, I hold an opinion with reasoning of my own, other people may differ, that entry to Sabarimala test, it is not qualifying the classical test of human rights. It is access. And it is restricted by the reasoning of a particular religion in a particular temple. Yes, I understand that there may be counter argument that it is in public space, it is in public domain. I understand. But it is, that is, if you take in that way, if the argument is taken to extreme, there will be an internal war, civil war between all Indian men and all Indian women. So it will be a battlefield between us. So we should balance. We should apply our finer sense of justice. Remember that only female judge of the bench is, that is obviously she is a very seasoned lawyer. There, Justice Malhotra got elevated from Supreme Court bar. And so in that way, I find reasoning, and I find that her reasoning is better than, quite unlike the biblical mythology of that it is less intelligent to get to consume the forbidden fruit. Not like that. So this is my position. I hope, Dhiraj, you understood my point. I'm not asking you to accept, but we are here just to share our ideas and opinions. We may still differ because democracy lies in dissent.
Yes, absolutely. Thanks.
Thanks.
So we have a question from Arun again. As you mentioned, certain aspects of constitution are changing and should change, and shouldn't we also change the test over these aspects?
Repeat.
As you mentioned, certain aspects of constitution are changing and should change. Shouldn't we also change the test over these aspects?
Last part is not very clear.
So basically the test which you mentioned.
Your UDHR test.
Yes,
So
sir.
yes, I appreciate the point. Now I got the point. UDHR test, it is also not final. That is, as I started with this premise that no law is final. UDHR also will be changed maybe after 500 years, maybe after 1,000 years. It will change. It ought to. But to my understanding that in this case, UDHR test is still valid because basic human rights UDHR is charged with so profound jurisprudence, and that is, it is celebrated across the world as one of the masterpiece documents in international jurisprudence. It is celebrated as better than UN Charter also. That is Universal Declaration of Human Rights. It is actually celebrated in several scholars hold it as the finest possible document international community has ever got. So in that way, but this also may change, but not in near future. I don't find immediately, especially in Sabarimala. Another thing we need to understand that the application of rights discourse everywhere, they are also the I have difficulty, and many Indian scholars, many non-Western scholars have difficulty. That, say for example, our dharmic jurisprudence, which is the ancient Indian legacy, there we always find the reference of duty. Not without reason that it was introduced by 42nd Amendment Act 1976 as fundamental duty. And it is very much celebrated during the present regime. That is for altogether different reason. But I find that this is our legacy. That is, if you take Indian legacy, duty-based approach is, if you read Dujuit is another sociological jurist. Dujuit clearly told, Leon Dujuit told, and Gandhi also reiterated in other words. Dujuit clearly told that if every man performs his duty, there is no relevance of right at all. So Gandhi also wrote it in a little different way that I have only one right. Human being has only one right and the right is to perform his duty. So very nicely told. So I find that if you take the rights-based approach and if you apply it with these traditional institutions called religion, ultimately it will indulge in social conflict. The way today men versus women type situation happened due to sovereign. But what is the teleological end of law? End means purpose. What is the teleological? What is the final purpose of law? Any law. The final purpose of law is to attain peace. The final purpose of law is to attain order and arrest chaos. So if we take care of this as the final end of law, final purpose of law, and if we take a duty-based approach, if all of us are dutiful, unfortunately it will not happen that. But if all of us are dutiful, in that case, right will turn redundant. That is the way, influenced by Occidental discourse, European discourse, we presuppose rights and non-negotiable. That is nothing except rights. But there is a unique Indian way, indigenous way of doing things. That ultimately, rights is meant for good governance. Duty also can do that. So in that way, I find that last year, not the least, I will repeat my point that state is one institution, religion is another institution. It is always better from governance perspective also, not only from law perspective, for governance perspective also. There are people to shout about everything. So thereafter, in case if father disciplines son by giving a slap, now should son go to police station? That is, if you take law, rights, etc., right not to be heard by another person to extreme, then there will be a chaos which will ultimately defeat the object and purpose of any legal system, legal tradition. So my sincere submission is that it is the inner faith, inner practice of a particular religious denomination or sect. But I don't appreciate whether it is just or unjust, right or wrong, fair or unfair. That is as different question altogether. But you cannot dispute with every fall of a hat. In classroom, I find many students are doing many things which I may not like. But unless and until it attracts gross disturbance of the classroom, as a teacher, I ignore it. So here ignorance is out of prudence. Here ignorance is not like that. That is, I am casual about discipline, or I am compromising with class discipline. Somebody may need to move to washroom. He or she may move to washroom. That is anyway not disturbing class. I don't mind. But if I take tough position, why during my classroom, during class hour, how dare you can? This is another. So this is a governance policy. I find prudence lies in not tinkering with exactly Justice Malhotra's point. So that is, rights are required for basic things. That is why I appreciate UDHR. But rights may not be taken to extreme. In that case, the ultimate object of law, to attain peace, to attain order, to defeat chaos, it will be defeated. This is my submission. Again, I hope I could address. I am not asking you to accept, but this is my position.
Yes, sir, sure.
So we have one more question by Devansh, and it will be the last question for the session.
Please.
He asked, why newer generation judges consider
what is the name of the student?
Devansh.
Devansh. Yes.
Yes, sir. Why newer generation judges consider the Western perspective on various subjects as universal, when our law curriculum is comprehensive enough to provide a greater understanding of the history and development of Indian laws and the society itself. So why would a learned lawyer consider a foreign perspective as superior or universal?
Oh, Devansh should be a philosopher, legal philosopher. I am confident. Yes,
I think so.
I need to listen to him once again. Please repeat a little slowly.
Okay, sir. Why newer generation judges consider the Western perspective on various subjects as universal, when our law curriculum is comprehensive enough to make a great understanding of history and development of Indian laws and the society itself. So he asked, why would a learned lawyer consider a foreign perspective as superior?
Devans, my straightforward answer to you that yes, uh, you have condemned our generation for Western perspective. Yes, we are guilty of. Yes, you are right. But at the same point of time, your curriculum was also drafted by our generation, isn't it? Your curriculum you did not draft. Your curriculum was also drafted by our generation. So here I find that there is a perspective difference of perspective. The way a judge thinks, read this book, how judges think. Uh, I'm forgetting the name. It's just how judges think. You right, you will get the name. Celebrated US author. He was US judge also, not Supreme Court, but a US District Court judge. But he wrote many books, Law and Literature, How Judges Think. So the way judges think, it is very, very different from the way academics think. So that is why I appreciate a different perspective offered by Justice Malhotra about women rights. Being a woman, she preferred not to afford this right. So this is very, very, very different from mainstream judicial discourse. As you can understand that her opinion was not honored because she was the lone judge. It was reduced to minority opinion. So here about women rights, men own. That is also a paradox. Male judgments own about women rights. So this will be there. Our maybe I am getting straightforward about answering you. That maybe our generation or uh, my father's generation is closer to colonial regime. My generation is also maybe suffering from hangover of colonial regime because very very near. I was born after 14 years of independence. My father was born in colonial India, but your generation is very very different because your generation. I am 100% sure that all of you, except uh, Madam and me, all of you are born in globalized India. If we take 1991, much after that. So your perspective will be very, very different. You people, and also the present governance regime is such that now there is time for revival of ancient Indian tradition, values, philosophy, etc. But at the same point of time, before we are condemned, our generation is condemned for colonial hangover. Kindly don't forget that the curriculum was made by our generation. Students don't make their own curriculum. So I hope I answered.
Thank you so much, sir, for answering all our questions. Now I request Praneet Kaur ma'am, Assistant Professor Law, to present vote of thanks to the esteemed speaker. Over to you.
Thank you very much, sir. Again, a very graceful and warm greetings of the day, sir. So, I, on behalf of our entire DBRNLU family, thank you for coming here and sharing your views on this topic, which is indeed very recent and burning topic. transformative constitutionalism. I think after your deliberation and how you dealt this topic, the students will vividly remember that what actually is transformative constitutionalism. Because while teaching, we have a mixed bag here, sir, of students. Few are from first year and few are from second year. The first year students, mostly who questioned you, they did not get any kind of exposure to the subject of jurisprudence, neither of constitution. Even I was surprised the line of questioning was very, very apt. So I think with this base and after your deliberation, I think they are going to have a very, very bright minds while they'll be dealing with the transformative constitutionalism or the subjects like jurisprudence and constitutions. Again, sir, on the behalf of entire family, I simply thank you for taking time out of your so busy schedule and enlightening each and every student with the wisdom you have. Thank you so much, sir. Thank you.
I'm really honored that I think this is one of the youngest law schools, and I'm really impressed also the quality of questions. It is indeed, I speak it honestly with 100% honesty. It is indeed a takeaway from my side from this session. Thank you.
The
Thanks.
pleasure is all ours, sir. Thank you so much, sir. Thank you.
Thank you, sir.
Thanks.
Thank you each and everyone who joined the session. I really appreciate the participation from first year. So let's meet up in the class and discuss this topic later. Thank you so much. Have a nice day, everyone.
Thank you, ma'am.
Thank you.
Thank you.